Viewers, welcome back to the Personal Injury Law Show. Before the break, we were talking about seatbelts and the fact that they've been in force for 40 years. What I want to do is go to some video footage of transport accident ads over the years dealing with seatbelts. We'll do that now.
Put your seatbelt on.
Bend your knee. Hold on, Katie. Bend your knee. Let yourself down slowly.
As the car decelerates, you leave your seat and smash into the windscreen. The forces fracture limbs and puncture your lungs. Then you're likely to collide with belted occupants, severely injuring them too.
I can't work out why I've been punished, you know. Just because I undid my seatbelt for a couple of seconds. Sorry.
Viewers, welcome back. Don, what did you think of those images?
Oh, look, I can't believe it's 40 years. I remember those videos like they were yesterday, Tony. Oh, look, I think they're very graphic, and they have to be graphic to get the point across. It's good that they do refresh these ones so they keep them fresh in people's mind. But I think 40 years, it's a long time, and people should wear seatbelts.
I've got my own personal experience, but Rob, what did you think of those ads?
Well, like Don said, that was a blast for the past for me, because I remember when I was so high watching these ads, and as Don says, they're very graphic, and they really do illustrate quite clearly the kinds of trauma that you can sustain in even low-speed accidents.
I want to give my own example. Many years ago, I was struck by a car side on, and we avoided the head-on. But I had a seatbelt on, and when we actually hit, I remember it just jarring up on me, and I fractured a couple of ribs. But I do recall if it wasn't for the seatbelt, who knows if I would have survived the accident, because it would have thrown me outside the car. So, viewers, please, I mean, the ads are there for a reason, but from personal experience, the seatbelts, it's the worst of two evils. Make sure you wear them. Let's go back to the cases, viewers. We've got a couple of interesting cases. We've got the case of Starrick and Edwards. South Australian decision 2010. Don, do you want to give me the facts?
Yeah, look, quickly, what happened was on a country road, there was a convoy of cars and trucks. There was two trucks in front, car in behind. They reached a stretch of the road where it appeared to be safe to overtake, so the car attempts to overtake the trucks, gets past the rear wheel of the second truck. The second truck pulls out to overtake the first truck and pushes the car onto the verge of the road, hitting gravel, losing control, and sustained significant injuries, Tony. In fact, paraplegia. The driver.
What did the court do here, Rob?
Tony, the court decided in favour of the plaintiff, the person who was driving the car. They decided that that car hadn't done anything wrong. They had just indicated carefully, they'd checked, they'd pulled out onto the side of the road and gone to overtake the truck. The truck hadn't looked carefully enough, put the indicators on and basically pulled out and pushed them onto the side of the road, and it was the truck's fault.
This plaintiff didn't have a seatbelt.
No, the driver did not have a seatbelt. Now, it was found they didn't have a seatbelt because when they found the car, which turned over, they put it back over, and obviously he was all over the place. And there's two issues. One, seatbelt lessening the injury. So had he worn the seatbelt, maybe he wouldn't have sustained the extent of the injury he did. But also two, Tony, which is interesting, was that they raised the issue that not having a seatbelt meant that he could not control the vehicle. He was flying all over the car, cars out of control, he couldn't press the brakes or apply the brakes or accelerate or control it properly.
I don't particularly like that argument, but the thing is, in terms of damage to the plaintiff, 55% came off, Rob. What do you think about that?
It was 25% in this case. It was just because of the mandatory South Australian contributory negligence.
Oh,
for
no,
not
you
seatbelt.
wanted 55% to come off.
No, I think in this case it was pretty well decided in that respect. I mean, I can't really see anything that demonstrated that that driver did anything wrong. It was really up to the truck driver.
And look, the only reason why it was reduced by 25% was because it's mandatory. The judge did not accept the other argument that didn't have control of the vehicle.
Do you think 25% is too much?
Look, I probably think it was, because look, it's 25% mandatory, but I think look, you've got to look at the number of factors, the extent of the injuries. I mean, even if you worn a seatbelt, the evidence always comes out that you could have sustained, people wearing seatbelts could also sustain those type of injuries as well.
The relevant legislation in South Australia says 25%'s got to come off. How much do you reckon would come off in the Victorian courts, Don?
Look, well, as a plaintiff lawyer, I'll be saying nothing. But look, I think it could vary depending on the extent of injuries. 10, 15% sometimes, 25% may be a bit high in these circumstances, particularly in this case where he did nothing wrong.
I reckon 25% could be a bit low in this one. What do you think?
Well, look, I think it'd have to come down to a clearer analysis of what his injuries were. If there was strong evidence to demonstrate that he wouldn't have sustained those sorts of injuries had he been secured by a seatbelt, then I'd have to agree that perhaps it could have gone even higher in terms of contributory negligence. Because if we can show that that seatbelt would have secured him and kept him safe, well, then all of a sudden, you know...
Well, let's be realistic. The lack of seatbelt meant that he's literally tossed around in the car.
Well, his head was in the footwell. He was
Yes.
upside down. It was, you know.
But look, people wearing seatbelts, look, it can lessen the injury, but on the same occasion, if it was a back injury, wearing a seatbelt, given the force involved, can also cause these type of spinal injuries.
Yeah, but if your back is held together and your body's held tight together, chances are there won't be that movement that can cause the damage to your back.
Look, potentially that's right, Tony. That is right. It
And-
depends on the medical evidence.
And when we were looking at those videos before, it's pretty clear that being held together is a lot better than actually being thrown out of the car
I'd have to agree with
or
that.
spun around inside the
I
car.
don't see any way that turning upside down in a car can be good for you.
Look,
You know what I mean?
I think if he sustained significant head injuries, because of hitting his head on the car, maybe a bit more of a reduction. Because of spinal injury, yeah, look, 25% mandatory might be a little bit high. I would have thought a little bit less in this case.
I liken what happened in this case to when you're at the show, you know, that ride you get in that just spins you around? Could you imagine being in there without belts?
I can't even think about that, Tony. I don't even like it with the belt, so...
You know what I mean? So basically, and this is at a very violent force.
Yeah.
Let's get on to the last case as time's flying. Richard and Mills. Rob, do you want to give me the facts briefly?
This one's interesting, Tony. There was a lady whose partner had left home to go to work. She realised he'd left his keys at home. She picked up the keys, got in her car and decided to race him to work, her plan being to somehow sidle up next to him on the freeway and wave him down. She starts weaving through traffic. She comes up behind the defendant, who's in the far right lane. The defendant is just sitting in his position going at 100 kilometres, doesn't move out of her way, so she decides to pull out to his left, overtake, and then pull in again in front of him.
She lost control.
She miscalculates and clips the front of his car. They both spin out of control, and she sustained some pretty nasty injuries.
What happened?
Well, she won a case, but there was significant reduction in her damages, 55%, Tony.
I reckon she's lucky to win her case. Rob, what do you think?
I think absolutely. She's doing these incredible manoeuvres, like replaying something out of a movie. And I think really the key element here is usually I would say it has to be her fault if she's just pulled in front of someone. But there was evidence to suggest that this defendant should have seen her coming and almost kept his speed going and pushed through her once the collision happened, as if he was just trying to block her out. Those
Which
facts
lane
change.
was he in? It's sort
He
of
was in the
confusing.
far right. He was in the far right lane.
Well, he shouldn't have been there, should he?
He shouldn't have been there. If he was travelling, you know, at that speed, he should have been in the far left lane to allow people to overtake.
Well,
Do you think 55% was too much?
I think it was. I think, look, you look at the driver, the defendant in this case, he was driving the right-hand lane. He should have been aware what she was intending to do. She apparently flashed the headlights at the driver. I think 55% was too high. He was
if that
aware.
was a policeman that was behind him and he didn't move, he would have been booked for that.
That's right.
But
and-
look, she shouldn't have been doing what she was doing.
Look, she shouldn't be doing, but she was wearing a seatbelt as well. So that coupled in the fact that the manoeuvres that she was doing, she did merge when she was probably too close to the defendant driver, and also wasn't wearing a seatbelt. 55%.
Well, she was an absolute imbecile, and the other guy didn't have a clue what was going on behind him. So anyway, viewers, thanks for watching the episode. After the break, we're going to have the mailbag, so please stay tuned. Thank you.